Yes.
Don Borlang Manik.
In the last question, this witness has received this one, but it was declared holiday, so it's going to be taken.
He came.
No, no.
You had applied for an application for recalling this witness.
Yes.
We allowed. So in that case, we have to allow.
We'll give him one more chance, and last chance.
Just one more.
Yes. Accused Dunbar Manik, produced from Jaintia Defense Counsel, JP Sarian present. Additional prosecutor S. Sansang present, and informed the court that on the previous date the witness appeared. However, it was declared holiday. Prosecution prays for the prosecution shall take steps to summon the witness. The prosecution takes a witness. It depicts evidence. Prosecution shall ensure that the witness is present on the next date fixed. If the witness is not present on the next date fixed, without any plausible cause, without any further order, the evidence of the prosecution shall stand closed. We given quite some time for to.
Yes,
And then don't forget that this person is UTP.
on 2 occasions, he received the summons.
Okay.
We'll give them last chance.
Please ensure that he is present on the next day.
Link Lawai.
Accused remanded back to 14 days judicial custody. Yes.
And in this case, the witness is DIO, which is transferred to another district. We have to serve fresh summon to another district.
Once they know that the witness has been transferred to some other districts, interdepartmental, they can forward the summon to the witness.
That should be, in fact.
Give that instructions to the police.
Yes, sir.
Okay. We are not passing order on that, but
Yes.
you do it at your
Yes,
level.
I'll do it at my level.
Yes. Where is the accused?
Tilik.
Right. Accused Craig Lawai present. Prosecutor S. LS Mbon present. And submits that someone issued to the witness return with the report that the witness is transferred. Where is he transferred?
Revive.
The witness is transferred to Viboy. Prosecution shall take fresh steps to refix for evidence. Yes.
Diamond Har. Thomas John. Amrit.
Yes.
In this case also, previously it was holiday, so taken. But some
UTPs are there in this case. You are representing whom?
Thomas John.
You are representing whom?
Perbatalang and Demon Hari.
Accused Demon Dhar present.
Yes, yes.
Accused Thomas Jones Reclam and Punbay Talang produced from Jail Azad through BC. Defense counsel for all the above mentioned accused persons are present. Additional prosecutor S. Chansang present and submits that the witness appeared on the previous date. However, it was declared holiday. Prosecution shall take fresh step. Refix for evidence. Accused Thomas Jones and Punbay remanded back to 14 days judicial custody. Yes.
Pesanteran.
Yes.
The witness said the witness has received the report but hasn't done it.
What is this case?
Accused is under presentation. 376.
This village is quite far, you know.
Can we wait?
Yes.
We'll wait sometimes. Quite far. And it's in border of Assam.
Okay, we'll wait for some time.
Yes.
Sparias Nakhar. Nimus Nakhar.
Yes. Accused Parios Dakar and Nibus Dakar are present. Learned additional prosecutor S. Kindia present. And this court has been informed that the legal aid counsel is on maternity leave. A fresh legal aid counsel, FB Pasa, had entered appearance and prays for time. Prayer allowed. Refix for final hearing of the instant case is deferred till next date. Please come prepared to the next day.
Okay. May I please sit down?
Yes.
Much obliged.
Yes. Yes.
Williamson Dhar.
Yes. Yes.
B.
Yes. Yes, madam. What happened to each aksha?
Yes, yes, sir.
Yes. Yes, madam.
Yesterday in the second half, she has submitted 3 more.
Yes, madam. Where are your experts from SP office? Yes.
Sir, he tried to fix it from the PC of women PS.
Sorry.
Then instruction, he tried to fix it from the CCTNS of women PS.
Has it been done?
No, it has processed. They start working, sir.
Sorry.
Now they are working at women PS.
No, have you checked? Has it been done?
Just now only I contact Majal, sir.
Done? Why he is not appeared before school?
I called him to appear and he said that he tried to fix for that problem, sir.
We are in trial, no?
I have
There's no
informed
question
him,
of
sir,
trying.
yesterday.
Huh?
Since yesterday also and this morning also I have emailed him and just now also I have contacted him, sir.
Call the SP. SP will appear. SP will appear. Yes, let the SP appear. He will appear with his own experts. We'll take up this matter. It's a very serious matter. It has got serious implications. Please try to understand that your entire investigation is under e-saksha. If it is not transmitted to the court, how are we going to proceed? And we are hearing on the, on the framing of charge. There's been argument advanced by the defense counsel that no case is made out for an offense of attempt to murder. And then the prosecutor has submitted that there are some evidence which is in e-saksha. We are hearing this matter. Can we defer the hearing the matter now just because the evidence has not been collected? Evidence is not there before this court. How cognizance of the offense was taken by the trial by the committal court? These are very serious questions. How this court does not have the power to take cognizance of the offense. When you file the charge sheet, you file the charge sheet before the committal court. The committal court, after perusing all the materials in the charge sheet, takes cognizance of the offense and commits the case. It raises a serious question mark as how the case was cognizance of the offense was taken by the committal court when the evidence collected by you was not placed before the committal court. And if you say that it was placed before the committal court through e-saksha, we want to have an access to e-saksha. Did the committal court had an access to the evidence collected by you? Have you gone through the charge sheet filed by you? Have you gone through the charge sheet? All the materials you have collected during the course of investigation, have you given a hard copy of all the materials in the charge sheet? Or you have uploaded the evidence collected by you in e-saksha?
I have uploaded, sir.
Then what has happened? Where has it gone? Why we are not having access to e-saksha? All that is required for the court is to have a password. We have the password. We have tried yesterday to have an access to e-saksha. The e-saksha says in the court you have personally seen that it shows blank. It means that your e-saksha is not connected to the court. You want to call that's why I asked you that call your experts who are uploading the e-saksha and connecting it to the court. If required, call the NIC also. We will look into it. We'll pass some order and pass it over to the law department or NIC or anybody else. This is the practical difficulties we are facing. You also have to tell the court now what is the practical difficulty faced by you. Evidence collected by you is not for the purpose of, it is for the purpose of trial. When it is not placed before the court, how can we proceed with the trial? Yesterday I told you that this is the first case we are trying where the evidence was collected through e-saksha. So we have not been able to have an access to e-saksha. The argument is going on based on the hard copy supplied to the accused persons. But the prosecution is taking a stand that there are some more other materials which is there in the charge sheet, but it is in e-saksha. So we need to have an access to e-saksha. We've given you time. SP will appear. And it's up to the SP. If he can explain everything, he'll explain. Or if he wants to come with the experts, let him come with the experts. What else we can do? We have the password. You should have checked it in the morning, na? When you came to the court. You should have coordinated with our staff and checked it. And if it was not there in our portal, or if it's not there in the portal, then something has to be done. 817 364. Please check it. You should have worked it out. The SP appears. And tell him that he's called to appear before court or because of this problem, and he has to come with his experts.
Okay, sir.
Yes.
Malasana.
Yes. Yes. 313.
Yes, sir.
What is the charge, madam?
376, sir.
How many witnesses are there?
We have started, Your Honor, in this case. 2 witnesses we have done.
Okay. Okay. Let's see if time permits. We don't have too many cases today.
Okay.
Okay. Be here. Cyrus Susni. Yes.
6433.
How many witnesses are there?
9 witnesses.
What is the charge?
376.
Be here. Yes. Yes.
Baking stone Sungkon.
Yes.
Diamond. Rotan.
Yes.
Your Honor, in this case, I don't know if the court has received
Bahak siap. MAC 2 2021.
So in this case, we had issued summon to SIDT vouchering the IO of this case and for production of the post-mortem report of the deceased. But we received a report, sir, that the officer is on law on or the duty, so he could not appear today, sir. He prayed for another date.
Who's appearing for the insurance company?
You know, I was informed yesterday by him. Said he cannot come today due to some personal difficulties.
He has to file adjournment.
I thought he'll file. He said maybe he'll send someone, but I don't know.
But what about the owner and driver? It's gone ex parte.
Yes.
Yes.
21. Case
Yes,
number,
sir.
miss case number, MS number 2. It's gone ex parte.
Yes.
All right. Learned counsel,
My
Srimati S. Kindia.
order dated 7/2/2024 for OP number 1. And OP number 2 is order dated
9-2.
7/2/24. No?
OP number 2 is 9-2.
9/2/22.
Yes, 9/2/24.
Learned counsel, Srimati S. India, present for the claimant. And the matter has proceeded ex parte against OP number
2.
1 and 2.
Yes, different dates, sir. For OP
Yes,
number 1.
proceeded ex parte against OP number 1 and 2. None appeared for the OP insurance. Summon issued to CW Shri D. Warjiri. Where's the order? Was this copy of order sent to him
Yes.
along with the summon?
No, sir. Only the summons.
Someone should have gone now with the order. Return with a report that the witness has expressed his inability to appear before this court today on the ground that he is engaged in law and order duty. Full stop. But not like this, Saman. Na? When you are asking the witness to appear, you have to tell him also why he is appearing in this case. It has to be written in the summon to appear with the postmortem report of the accused, so and so, everything.
I have mentioned, sir, for production
Where?
of. I've mentioned for
Production
production of the
okay, yes,
post-mortem report
yes,
in
yes,
relation with the cleared PS case.
yes. But this court has failed to comprehend. The witness who is an IO of the accident case is withholding the postmortem report for the best reason known to him. Even if he is not in a position to appear before this court today, he ought to have forwarded the postmortem report to this court, to this tribunal. Full stop. The petitioner, the claimant is allowed to take fresh step along with the copy of order dated 18/6/2026 and order passed today. Fix for evidence. Both the order, annex both the order, okay?
Yes.
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 Then number 2.
Same,
order.
sir. 1 and 2 sinks.
Sanchar Sharma.
Yes.
Your Honor, I just want request with the
1 minute, 1 minute. MSC case number 1. You are there in number 1?
2, 3, 4.
We are on number 1.
122.
MSC case number 1. You are there in number 1?
No, I'm here.
Yes.
When I'm filing this one CW's deposition,
A copy for this thing also.
yes, I'll leave it with the court.
Learned counsel, series also for the claimant present and has filed the deposition of
CW6.
CW6 on affidavit. None appeared for OP insurance. Fix for appearance of the OP insurance. Your CWs are finished?
No, some more. Because he's not coming today, I'm filing one, otherwise would have brought some cross.
File together. Fix for further CWs. Fix for evidence of further CWs. Needless to say, the claimant shall file the deposition of CWs on affidavit with a copy to the OPs. Yes. Yes.
Katupai 225.
Yes.
Your Honor, in this case, with Madam Sichal, we have we require the attendance of the advisory to submit the postmortem of the decision. Same order with Madam Sichal.
All right. Learned counsel for the claimant present. Learned counsel E. Manso.
Yes, sir.
Learned counsel E. Manso for the claimant present. None appeared for the OP insurance. Counsel for the claimant prays for time for further evidence. Pray aloud.
Yes.
Panchayat High.
Same order.
Same matter.
Implementing.
Application praying for including the mother of the deceased as a claimant. The same order this in this MSC number 3. Claimant has filed a petition number 7/2026.
Yes.
Inter-alia, praying for impleading the mother of the deceased.
Yes, yes, sir.
The matter is fixed today for show cause by the OP insurance. OP insurance is given last chance to file show cause, failing which the application will be decided without the show cause of OP insurance. Yes.
Pilmi High.
This is also same order.
None appear for OP insurance. Pick for further evidence. This one. Here also you want to implead anybody?
Yeah. This is
Any impleading application filed by you?
Yes, Your Honor. Regarding with this MSc 3 and MSc 5, only that one. Filming file is the mother of.
You file impleading application.
Yes. No impleading on this filming file.
Okay. Okay. Then number 5 will same order.
Yes, sir.
Yes. 4 and 5 same order for further evidence. When the IO comes, then you will like
Yes.
to use his evidence in your case.
Yes.
Okay.
I have like it.
Yeah. Yes. 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 Do you have any witness?
No, one more MSc case.
Oh yes. 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 Okay. Tell me, you are for claimant.
When I've just gone through the file just now, it seems one application has been filed with the Council of Insurance.
Chando.
His file is power today.
He's here.
I have not seen him, but seems he's sent to someone. One issue is there in this case. Your Honor has raised the point where the claim was first instituted in Assam or here. So he had sought time for clarification on that. We give him time on that. But as per the CIS report, it seems it was instituted here in Jaintia first. Because as per section 166, subsection 3, 4.
160.
166, subsection 4. Says the claim tribunal shall treat any report of accident forwarded to it under section so as an application for compensation. So this matter was taken cognizance by this court on 3/11/2025.
Any idea what is the status of this?
In Assam.
No, status of clause 3.
No, from Supreme Court not yet.
But Supreme Court has stated.
It has stated its application or the operation of section 3. But no further hearing has been conducted.
That means this time limit prescribed for filing.
As for now, it has been stayed.
It's been suspended. That means there is no limitation.
No limitation. We'll let him clarify on that point. It will be better. He'll be in a better position to say.
There are counsel for the claimant. She is also present. This tribunal by order dated 15/6/2026 has sought the appearance of the OP insurance to clarify if a claim petition has been preferred with regard to the compensation arising out of the accident, arising out of the motor accident in the instant case before the tribunal at Silchar. stop. The OP insurance has entered appearance through entered appearance through the counsel Shri B.K. Chandok, C-H-A-N-D-A-D-O, Chandok, D-O-K. See, na? Whenever they file any wakalatnama from different high courts or anywhere, na? Either it has to be countersigned here by the bar here, or they have to countersign here.
Seal. We have a seal here.
They have to get sealed here. Okay. Or they have to file along with this wakalatnama, the local wakalatnama. Okay. What is it? And has filed a petition number so and so. Praying for time to file written statement. Stop. Prayer of the OP insurance is allowed. Learned counsel Srimati present for OP. Who driver?
No, Your Honor, the pedestrians,
Huh?
the party involved in the accident, Your Honor.
But who is he?
She's a pedestrian, Your Honor.
For the
She
claimant.
doesn't have a case here. She was one of the party who was involved in the accident. She's a pedestrian passing by and the truck has hit her. She had appeared for that lady who had filed a claim in God.
And you are appearing for whom?
I'm
You are
for this Paibyang who had filed a claim petition.
Learned counsel Susi present for the injured. Sorry. Full stop.
I'm for the Paibyang.
All right. This then the counsel do that. Counsel for Paibyang. Fix for written statement by the OP insurance. We'll see that the written statement comes. Fix for written statement and clarification by OP insurance.
Election. Take up 313.
Any evidence?
No evidence. We are waiting for one of the witnesses. Till now, she has not come. Actually, this place, I doubt it's in West Jaintia, somewhere in Assam. Border, it's in
Which case?
result from item number 4. But received, someone has received.
Okay, we'll see sometime. Okay. Then we can pass the order if the witness fails to appear during the course of the day. The prosecution shall be at liberty to take coercive steps to secure the presence of the witness.
It is under representation.
The defense has filed a petition number 84/2026 dated 37/2026 praying for dispensing the personal appearance of the accused for the day. Allowed. Yes.
I have a bail application.
Yes. See, here. Yes.
So the expert is on his way, and I called SP didn't pick up the calls. May I please, sir, this is a session case number 1026/2026, and this is the first bail application filed before this honorable court, and there are no other bail application pending before any other court.
Yes. Yes.
So the ground for
Where is the IO in this case? The IO? Yes. Yes, please tell us.
So the ground for the bail is that the allegation as alleged by the complainant in
How
the
long is in custody?
111 days till yesterday and plus today 112 days. The case has been charge sheeted by charge sheet number 21 dated
When was the
21.
charge sheet filed?
Pardon, sir?
When was the charge sheet filed?
21/5/2026. Charge
When
sheet
was the
number
FIR
11.
filed?
10/4/2026.
Charge sheet filed?
21/5/2026. Charge sheet number 11.
Under section?
115 clause 1, 109, and 351 clause 1.
What are these sections?
115 clause 1, it's a voluntary causing hurt. And 109, it's attempt to murder. And 351 clause 1 is criminal intimidation. Part 1.
Yes.
Now, the allegation made against him is totally false, frivolous, and fictitious. Now, the investigation has been completed. Until today, 2 months after the filing of the charge sheet, no further inquiry or no further recovery was made. Neither any further investigation was needed. So his further detention in jail is not required anymore,
Why you say so?
because the case has been charge sheeted and the investigation has been completed. And also the statement of the witness also has been recorded.
Detention of an accused. Detention of an accused during investigation is under which regime of law? When an accused is detained during investigation, under what provision of law he is detained? What is the distinction between detention of an accused during investigation and detention of an accused during trial? Are you arguing that once the charge sheet has been filed, the accused is entitled to be released on bail?
Pardon, sir?
You are saying that once the charge sheet has been filed, the accused is entitled to be released on bail?
Yes, sir. If he is not needed.
Show me the law. Which law says that after filing of charge sheet, the accused is entitled to be released on bail? See, if you are arguing on law, show me the law. If you are arguing on facts, show me the facts. If you say that the law says that once the charge sheet has been filed, he is entitled to be enlarged on bail, show me the law which says that after filing of the charge sheet, the accused is entitled to be released on bail. Which law says so? What is the purpose of detention of an accused during investigation?
The chances of hampering or tampering with the evidence. That's why his purpose of keeping him in jail will to protect him from hampering or tampering with the evidence.
And what is the purpose of keeping the accused in jail after charge sheet?
To secure his appearance.
Only appearance.
And also to not.
What is the power of the court to remand the accused in custody during investigation?
Power to.
Yes.
Power to remand.
Who keeps the accused in jail? Police is to arrest. And who authorizes his detention in jail?
The court.
Where is the power of the court to do so? What is the corresponding section under BNS of section 167? Yes. What is 7?
187.
Yes, please read 187.
Procedure when investigation cannot be completed in 24 hours. Clause 1. Whenever any person is arrested and detained in custody, and it appears that the investigation cannot be completed within a period of 24 hours fixed by Section 1258, and there are grounds for believing that the accusation or information is well founded, the officer in charge of the police station or the police officer making the investigation, if he is not below the rank of sub-inspector, shall forthwith transmit to the nearest magistrate a copy of the entries in the diary, hereinafter specified related to the case, and shall at the same time forward the accused to such magistrate.
Yes.
Clause 2. The magistrate to whom the accused person is forwarded under this section may, irrespective of whether he has or has no jurisdiction to try the case, after taking into consideration whether such person has not been released on bail or his bail has been cancelled, authorize from time to time the detention of the accused in such custody as magistrate thinks fit, for a term not exceeding 15 days in the whole or in the part, at any time during the initial 40 days or 60 days, out of detention period of 60 days or 90 days, as the case may be, as provided in
Please read
subsequent.
that part again.
Pardon, sir?
Please read that part again.
The magistrate to whom an accused
1
person
minute, 1
is
Yes, you reading? Subsection?
Subsection 2. The magistrate to whom an accused person is forwarded under this section may, irrespective of whether he has or has no jurisdiction to try the case, after taking into consideration whether such person has not been released on bail or his bail has been cancelled, authorize from time to time the detention of the accused in such custody as such magistrate thinks fit, for a term not exceeding 15 days in the whole or in part at any time during the initial 40 days or 60 days, out of detention period of 60 days or 90 days, as the case may be, as provided in subsection 3. And if he has no jurisdiction to try the case or commit it for trial and considered further detention unnecessary, he may order the accused to be forwarded to a magistrate having such jurisdiction. Now, clause 3. The magistrate may authorize the detention of the accused person beyond the period of 15 days if he is satisfied that adequate ground exists for doing so, but no magistrate shall authorize the detention of the accused person in custody under this subsection for a total period exceeding clause 1, 90 days, where the investigation relates to an offense punishable with death, imprisonment for life, or imprisonment for a term of 10 years or more. Clause 2, 60 days, where the investigation relates to any other offense. And on the expiry of the set period of 90 days or 60 days, as the case may be, the accused person shall be released on bail if he is prepared to and thus furnish bail. And every person released on bail under this subsection shall be deemed to be so released under the provision of chapter 35, chapter 35 for the purpose of that chapter. Number 4. No magistrate shall authorize detention of the accused in custody of the police under this section unless the accused is produced before him in person for the first time and subsequently every time till the accused remain in the custody of the police, but the magistrate may extend further detention in judicial custody on production of the accused either in person or through an audio, video, electronic means.
Please read para 4 again. Clause 4.
No magistrate shall authorize detention of the accused in custody of the police under this section unless the accused person is produced before him in person for the first time and subsequently every time the accused remain in custody of the police, but the magistrate may extend further detention in judicial custody on production of the accused either in person or through the audio video electronic means.
Next.
No magistrate of the second class, not specifically empowered in this behalf by the High Court, shall authorize detention in the custody of the police.
Yes. Yes. Next explanation.
60 days.
Explanation.
Of
What is the explanation? now?
explanation. For the avoidance of doubt, it is hereby declared that notwithstanding the expiry of the period specified in subsection 3, 19 and 16, the accused shall be detained in custody so long as he does not furnish bail. Explanation 2. If any question arises whether an accused person was produced before the magistrate as required under subsection 4, for the detention. The production of the accused person may be proved by his signature on the order authorizing detention or by the order certified by the magistrate as to production of the accused person through the audio, video, electronic means as the case may be. Provided that in the case of a woman under 18 years of age, the detention shall be authorized to be in the custody of a remand home or recognized social institution. And also provided further that no person shall be detained otherwise than in police station, under police custody, or in prison, under judicial custody, or a place declared as prison by the central government or the state government.
Then, notwithstanding
anything contained in subsection 1 to subsection 5, the officer in charge of the police station or the police officer making an investigation, if he is not below the rank of sub-inspector, may, where a magistrate is not available, transmit to the nearest executive magistrate on whom the power of a magistrate have been conferred a copy of the entry in the diary herein after specified relating to the case, and shall at the same time forward the accused to such executive magistrate, and thereupon such executive magistrate may, for reason to be recorded in writing, authorize the detention of the accused person in such custody as he may think fit for a term not exceeding 7 days in the aggregate. And on the expiry of the period of detention so authorized, the accused person shall be released on bail except where an order for further detention of the accused person has been made by a magistrate competent to make such order, and where an order for such further detention is made, the period during which the accused person was detained in custody under the orders made by an executive magistrate under this subsection shall be taken into account in computing the period specified in subsection 3. Provided that before the expiry of the period aforesaid, the executive magistrate shall transmit to the nearest judicial magistrate the record of the case together with a copy of the entries in the diary relating to the case, which was transmitted to him by the officer in charge of the police station or the police officer making the investigation as the case may be. A magistrate authorizing under this section detention in the custody of the police shall record his reason for doing so. Any magistrate order other than the chief judicial magistrate making such order shall forward a copy of his order with his reasons for making it to the Chief Judicial Magistrate. If in any case triable by a magistrate as a summoned case, the investigation is not concluded within a period of 6 months from the date on which the accused was arrested, the magistrate shall make an order stopping further investigation into the offence unless the officer making the investigation satisfies the magistrate that for special reason and in the interest of justice, the continuation of the investigation beyond the period of 6 months is necessary. Now, 10th, where any order stopping further investigation into an offence has been made under subsection 9, the session judge may, if he is satisfied on an application made to him or otherwise that further investigation into the offence ought to be made, vacate the order made under subsection 9 and direct further investigation to be made into the offence subject to such directions with regard to bail and other matters as he may specify.
Yes. 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 Yes.
So this case, now the FIR was filed on 10th April. 21/5, that is 1 month after, 1 month, 1 month, 10 days, the case was charge sheeted. And the investigation also completed by charge sheet number 11. So till today, 2 months after the charge sheet, 2 months after charge sheet, no further investigation, no further recoveries, or no further evidence were collected from the needed required from the by the IO from the accused person. So here, even though 109 is there, the question of 90 days cannot be made out. And then the question of 60 days also to any other offense also was not made out. So
I'm not being able to understand what you are asking. Tell me, give me the difference.
Default bill. Your default bill, the charge sheet is there.
and also the punishment charge against the accused was neither imprisonment for life, one of the ground neither imprisonment for life or death or punishment for death punishment. And the accused person doesn't have any criminal antecedent. So I pray before the court that the accused person may be released on bail on the terms and conditions.
Why is she releasing bail?
Because he is no more needed in this case when it comes to investigation. The investigation has been closed.
He's not needed now anymore.
He is needed when the trial commences. His appearance is needed.
So that's what I'm asking you. When a person is kept in jail, police exercises power under section 41 of CRPC and section 35 of the BNSS. He exercises the power to arrest, but they can arrest and keep a person only for 24 hours, not beyond that. And if they want to keep it beyond 24 hours, then they require the permission of the court or approval of the court. In other words, if they require further detention of a person more than 24 hours, they will require a remand order from the court. And then during investigation, the person can be kept in police custody as well as judicial custody.
Yes.
But a person can be kept in custody at one go only for 15 days.
Yes.
After 15 days, he can be remanded again. Earlier, the law was this: prior to BNSS, a person can be kept in police custody only for the first 15 days. If custody was not taken within police custody was not taken within first 15 days, he cannot be remanded into police custody anymore. But now in BNSS, he can be taken in from judicial custody to police custody, any custody. So the person during investigation can be kept in police custody as well as judicial custody. Where is the power of the court to remand? Just now you read, no?
Yes. 187 clause 3.
187 provides the power of the court to remand the accused in custody for the purpose of investigation. Isn't it?
Yes.
And if the investigation cannot be completed within 90 days and 60 days, then what happens? No more remands. The court will not no more remand. And the accused acquires the right to be enlarged on bail. It is the right of the accused to be enlarged on bail if the investigation is not completed within 60 days or 90 days. The court does not have any more authority to remand the accused in custody. But they have, you read the clause there, even if the court releases him on bail, passes a bail order, refuses to remand, but will not release the accused until unless he furnishes the sureties. So, the power of the court to remand the accused during investigation is under section 187, isn't it? So after the charge sheet has been filed, your argument is this: after the charge sheet has been filed, isn't it? The accused is not required, isn't it?
Yes.
So the court also does not have, the court under 187 has got the power to remand the accused only for investigation. After investigation is over, where is the power of the court to remand the accused? This is only for the investigation. So after the investigation is over, where is the power of the court to remand? After the investigation is over, where is the power of the court to remand? Can a person be remanded to police custody after the investigation is over? Your argument is this, isn't it? That the investigation is over, he should be released on bail.
Yes, sir.
Why?
Because he is no more required in the
So
investigation.
that means after charge sheet, all the accused person should be released on bail. He's not required. Accused is required during investigation. By whom?
By the IO.
And after charge sheet, who requires the accused? Who needs the accused?
The court.
Where is the power of the court to detain him?
Clause 4. No magistrate shall authorize detention of the accused in custody of the police under this section unless the accused is produced before him in person for the first time and subsequently every time till the accused remain in the custody of the police, but the magistrate may extend further in detention in judicial custody on production of the accused either in person or through an audio video electronic means.
It's section 346.
If the court, after taking cognizance of an offence, clause 2. I'll read the whole clause. In every inquiry or trial, the proceedings shall be continued from day-to-day basis until all the witnesses in attendance have been examined, unless the court find the adjournment of the same beyond the following day to be necessary for reason to be recorded, provided that when the inquiry or trial relates to an offence under section 64, 65, 66, 67, 68, 70, 71 of the BNS 2023, the inquiry or trial shall be completed within a period of 2 months from the date of filing the charge sheet. Clause 2. If the court, after taking cognizance of an offence or commencement of trial, find it necessary or advisable to postpone the commencement of or adjourn any inquiry or trial, it may from time to time, for reason to be recorded, postpone or adjourn the same on such terms as it thinks fit for such time as it considered reasonable, and may by a warrant remand the accused if in custody, provided that no court shall remand an accused person to custody under this section for a term exceeding 15 days at a time, provided further that when witnesses are in attendance, no adjournment or postponement shall be granted without examining them, except for special reason to be recorded in writing. Provided also that no adjournment shall be granted for the purpose only of enabling the accused person to show cause against the sentence proposed to be imposed on him. Provided also that no adjournment shall be granted at the request of a party except where the circumstances are beyond the control of that party. Where the circumstances are beyond the control of the party, not more than 2 adjournments may be granted by the court after hearing the objection of the other party and for the reasons to be recorded in writing. Clause C. The fact that the advocate of a party is engaged in another court shall not be a ground for adjournment. Now, where a witness is present in court but a party or his advocate is not present, or the party or his advocate, though present in court, is not ready to examine or cross-examine the witness, the court may, if think fit, record the statement of the witness and pass such order as it thinks fit. Dispensing, as it thinks fit, dispensing with the examination in chief or cross-examination of the witness as the case may be. Now, explanation 1. If sufficient evidence has been obtained to raise a suspicion that the accused may have committed an offence and it appears likely that further evidence may be obtained by a remand, this is a reasonable cause for a remand.
Okay.
Explanation 2. The term on which an adjournment or postponement may be granted include.
So, when the trial is on, the accused is remanded by the court exercising power under section
346.
So 346 explanation says what? If sufficient evidence has been there, once the charge sheet has been filed, it becomes a hopeless case for bail. During investigation, yes, we can understand. The matter is under investigation, they are not collecting the evidence, nothing is there. But the matter has, charge sheet has been filed. Means what? Investigation is over, they have collected the evidence. Why should a person be granted bail when there is a charge sheet? During investigation, only FIR is there. The police is in the process of collecting evidence.
Yes.
So there is not much evidence against the accused. So that may be a case for granting bail during investigation. But if the investigation is concluded and a charge sheet has been filed, that means investigation is over. They have collected evidence against you. Now you have to stand for trial. And the explanation says that if the sufficient evidence has been obtained to raise suspicion that the accused has been committed an offence, and it appears that likely further evidence may be obtained by remand, this is a reasonable cause for remand. After charge sheet has been filed, for the purpose of trial, when the accused is remanded, the court exercises power under section 346. The earlier old law was section 309. You don't say that once the charge sheet has been filed, you acquire the right to be enlarged on bail. You loses the right. If the charge sheet is not filed, within 90 days, you acquire the right. You have to exercise that right. And if you don't exercise that right, and a charge sheet has been filed, you lose the right. You lose the right. And no more default bail. So what is your case? On law, you are not entitled to bail. No statutory bail. On facts, what?
No sufficient evidence against the accused person for the allegation made against him
Yes.
from the evidence
Yes.
collected.
Yes.
Yes, sir, from the statement of the victim, there is done incriminating materials collected during the investigation that the accused person had committed the offence against his wife. So if the
What
accused,
offence?
as per the statement, their husband
What
and wife,
offence?
is that he had assaulted his wife twice,
What is the punishment for assaulting?
it's, which may extend to 1 year.
1 year. Bailable offence.
Yes, and 109 to 10 years.
Sorry.
And 109 also.
Section 300, section 10.
Yes,
What is the punishment for section 115?
Extend to 1 year.
Is
With-
bailable
or with
offence.
fine. Or
Yes.
with fine.
Bail in a bailable offence is a matter of right.
Yes.
You can't make any objection on that.
Yes. But the second part of the evidence.
What are
that
the offence? We already the charge sheet is there before this court. We have not commenced with the trial. Now, what is the offence again as per the charge sheet? What is the offence?
109, sir, for attempt to murder.
What is the evidence of attempt to murder?
Yes, that's that he had committed the offence twice, on the first on the 9th and then second on the 10th.
What is the offence he committed?
Yes, he's trying to kill his wife by dragging.
What is that
herself
evidence?
from
What is that evidence that he was trying to kill his wife?
that the evidence, the statement of the victims.
Where?
She stated that she was dragged by the accused person
Where
by
she
her
say?
husband.
Where she
To-
says?
I'll just read.
Where she says?
I'll read only the relevant portions of the second part.
Where she says?
Into 160.
Show the FIR.
That second part is on the 10th. I'll read on that paragraph that on the following day, that is the 10th.
Where are you reading? Statement 164.
164.
Yeah.
On the following, that is the 10/4/2026.
Where are you? Yes, yes.
We left the Orchid Hotel Yelong at around 8:30 a.m. and we went to his residence at Yelong Dong Mission and we had breakfast there. After sitting for a while, he asked me to go with him to the shop for buying cannabis and I declined to go with him. He got angry because I refused and he scolded me. So I was forced to go with him. On returning back to his house, on the way we met a friend named Jeff from Bai and he spoke to me and he said, "Oh, you are here?" And I replied, "Yes." I asked William why. He did not speak of to Jeff, although Jeff was friendly towards him. Then William replied that, "Why should I talk to him?" As he smiled at me, because he also had got you. I asked him to stop talking about us, as Jeff is a long time
No,
friend. Then
nothing.
William,
Nothing. What are you reading? Where is that attempt to murder?
because here, Your Honor, the next line, he pulled me to his sister's bedroom and then he slapped me and scolded me and kept blaming me that I had slept with Jeff. He threatened that he will end my life that day. Then he strangled me with his hand around his neck.
Then after that, what did he?
He
strangulated the neck. And then what did he
She
do?
begged for forgiveness.
And then what did he do?
Then he released her.
Then?
But he had made an attempt to strangulate
Oh,
her
really?
next day. Only when she asked for forgiveness, then he released her. Then after that, he
Attempt
just
to
read-
murder means what you did. Attempt to murder means you did everything to kill her. Had you succeeded, she would have died.
Yes.
That is attempt to murder.
Yes.
But here he had strangulated her, and then she said, "Please forgive me." He left her.
Yes, but the injury report of the victim also clearly shows that there are multiple injury on the part of her body.
Yesterday we read another judgment.
Yes. Yes.
When any act becomes attempt to murder, if you stab somebody, it becomes attempt to murder.
Has to be done.
If you hit somebody, maybe he gets a wound on his hand or in his leg. You hit somebody with a sharp weapon. What is the distinction between 326 and 307?
Yeah, intention and knowledge.
Look, we have to gather from the circumstances. Na?
Yes, from the-
They are husband. They say husband
They are
and wife, and you are husband and wife, madam.
Yes, sir.
They are husband and wife. You file the you claim yourself to be the husband,
Yes.
and in the FIR he says the what?
Samla.
What samla means what?
Boyfriend. In the FIR, she says some boyfriend.
That is
In
why
the
I asked
police-
you. What's the difference between boyfriend and husband? What is the difference between a boyfriend and a husband? A relationship between a man and a woman is a mutual relationship. Such kind of relationship is not recognized. Only living in relationship is recognized under the Domestic Violence Act. You see that you are husband and wife. So if
She is my wife.
so, once you are married and your marriage is recognized by law, it gives rise to a conjugal right.
Yes.
It is nothing wrong to sleep with a woman who is your wife. The wife cannot come and complain that he raped me. In India, we don't have marital rape. So that's why the definition of rape also it excludes sexual intercourse with wife is not a rape. That's altogether a different subject. What is marriage? The sexual intercourse between wife and a husband is integral part of a marriage. So, but then you say that I'm the husband. The wife files a complaint saying that Samla.
That's what. In the FIR, she say I am her Samla.
Yes.
Before the police, she say I'm her husband.
Where she says?
In her statement.
Yeah.
180 BNS says, on examination, I am to state that my name and address is as stated
No,
above.
164 what she says. That she says that the accused is my husband.
No, sir, she never mentioned that I am her husband or boyfriend.
But in 161,
But before the police, she said that I am her
where's
husband.
the statement before the police?
On examination, I am to state that my
Yes,
name,
madam, you are the investigating officer.
my name and address is as stated above.
you have
I am a
investigated the
service
matter.
girl at Bourbon
Yes, one
Restaurant,
second.
Jawai.
160, 161, 180, DNS, where is the statement? You investigated the matter? During the investigation, what was the relationship you found?
She stated that the accused is her husband, sir.
Did you investigate in that aspect of the matter whether they are husband and wife? Hmm? Where which is the husband?
Line number 3.
Is my husband.
Sri Williamson is my husband and I know him for about 4 months.
Yes. Yes, madam. Your investigation says what?
Yes, sir. The victim stated that the accused is her husband, sir. As per the statement given by her.
Sorry.
As per her statement given by her son.
If somebody tells you you are a police officer investigating a case, somebody says that I am the owner of the house. You record it, I am the owner of the house. If there is some crime committed arising out of a property dispute, and the person says that, look, I am the owner of the house. You just say that, yes, you are the owner of the house. What will you do next step? If a person says that I am the owner of the house?
I will ask for the landholding certificate.
Yes. So in this case, did you ask? Do you have anything to show that you are? Huh?
They have not legally married, sir.
Sorry?
They have not legally married.
What is illegal marriage?
They have not owned the certificate.
Huh?
Because
What is legal marriage and what is illegal marriage?
they have not married in the court, I think.
Where does it say that people have to get married in the court? They might have married in according to the custom. You are Panar.
Yes, sir.
What is the custom here for the marriage?
It just married, never.
Huh?
We never get any certificate from the court, sir.
How will know that this man is his wife or this man is his husband? How will know? There are police officers, there are so many. How will we know that that these two couples are husband and wife? As per the custom, how will we know they are husband and wife?
After they have it, after both the husband and wife, they disclose their relationship to the relatives, sir.
They stay together and they tell the family that we are husband and wife.
Yes, sir. The accused took the victim to his grandmother residence.
Then this accused also, the uncle also said that he keeps on bringing girl in his house. He brought 4 women. All the 4 were the wife.
Yes, sir.
4 wives.
The 4 wives, but he has separated from them.
But you did not collect any evidence that he is the wife. Did anybody say that they are husband and wife, the family members? As per the custom here is that a person stays together and informs the family that they are husband and wife. Did they inform to the elders that they are married now, they are living as husband and wife? Anything? No.
So his mother's statement, she stated that I saw his wife, but I did not know her name.
Okay. Yes. Anything else here?
Only from the statement of the 164 of the victims. And my only ground for objection is that if you might pose threat to the victim prior to the
All right,
evidence.
it's okay.
But as per the statement, there's nothing more, sir, except that.
No, but we are not at the bail stage. That we have already discussed about the stage in which we grant bail. We are not at the bail stage. We are at the stage of, investigation is completed. Now we are at the stage of trial. Now at the trial stage, the offence for which charge sheet has been filed is a voluntary hurt. The punishment is
Which
1 year.
extend to 1 year.
Then next is 315, criminal interpretation. What is the punishment?
That is still which may extend to 3 years as per the Meghalaya Amendment 2014.
3 years.
So 3 years.
All right, there also we can consider the. So with these sections, how can we detain him? Attempt to murder. Tell me, what is the evidence of attempt to murder?
That is the only one which I have just read now. So otherwise, other than that, nothing else on record.
Yes.
So the IO said the mother.
Huh?
The IO said the mother said that it's his wife. Yes, his grandmother. Noting the fact that his grandmother is 73 years old. So mere bringing a woman, mere having a friend who is a woman, and for some work I take her home, it doesn't mean that she is my wife. Until and unless we stay together, like with the complainant convicted.
Madam, which world do you live? Are you reading some outdated books over? Or you don't know how people live? We are not. Are we doing some academic study? We are on some case, and when we try to understand these cases, we have to be very lively to the reality of life, how people live. That is why under the Domestic Violence Act, we have recognized the living in relationship. So people might be living in relationship. You don't understand. If a person is a lawfully wedded wife, so many civil rights flows from that. She'll be entitled to the property. She'll be entitled to this. A lot of rights will accrue because of this legal relationship. So a person, even if he's a government servant, so the wife will be entitled to pension. And here we are talking about the word wife. Wife means legally wedded woman. A man can bring a woman and stay with the woman. There's no issues about it. He's free to do that. Both are major. They can stay where the manner in which they want to stay. There's no problem. Why should the law interfere? But when it comes to the right of that woman, then the question comes that because you are not lawfully staying together, then what happens to the children? Law is not so simple. Yeah, this is a bail application. This is a bail application under section. You are filed under section 483. It is parameter with section 439. Is it the corresponding section is 439?
Yes,
We are not going to exercise power under 437.
sir, 439.
Is 439?
Yes.
No, right. This is a bail application under section 483 of BNSS for the grant of bail of the accused William Dakhar or Dalkhar. But what have you written? What have you written here in the cost title? Bail application?
It's William Sandhar.
So you have to understand why do you write like this in the court? What's so special about like this? Why do we write like this in the court applications? Why? Why do we write cost title like this? It's for the court, na? So that it becomes very easy for us to understand what is this application. It becomes very easy for us to pass the order. But here you have written what? Name of the accused also mistake. Please correct it. Is Dhar or Dakhar?
Dhar. DHAR.
This is a bail application for the release of the accused William Dhar in connection with session case number 10/2026 under section 115/2109/3511 BNS 2013. The application is moved by learned counsel Srimati M. Suchia.
ML Suchia.
ML Suchia. Heard learned counsel for the petitioner. Heard learned additional prosecutor. Srimati so-and-so. The IO of the IO of the instant case. Your good name, please. WPSI.
SAIN.
Is present with court to assist the court. Stop. On perusal of the record, it emerges that the criminal proceeding was set in motion by the informant stroke victim via FIR dated 10/4/2026. We have the English translation of the FIR.
I have enclosed it, sir,
Where? In the application.
in the bill application.
In the FIR, it has been alleged that the accused is the boyfriend of the informant he had physically assaulted her on 9 April 2026 and thereafter again on 10 April 2026 the accused strangulated her neck by tying a shawl and dragged her inside the forest forcefully with an intention to hang her. Fortunately, the uncle of the informant intervened and rescued the victim. The FIR was registered as Women PS case number 7/4/2026 under section 115(2) the same thing BNS, and the case was entrusted to WPSI S. Sumer for investigation. The investigation concluded in a charge sheet number 11/2026 dated 21/5/2026 under the same sections against the accused. Stop. The charge sheet was laid before the committal court, laid before the learned CGM. Where's the committal order? And the case was committed to this court White committal order dated. The order date. Which order? 3/7/2026. This case is at the stage of hearing before consideration of charges. Full stop. The accused was arrested when?
10th April, 10/4/2026.
The accused was arrested on 10/4/2026. He has been in custody. He has been languishing in custody for 111 days. Full stop. Learned counsel for the petitioner. Learned counsel for the accused. I submit that the evidence collected by the investigating officer does not prima facie disclose offense under section 109 bracket attempt to murder. Stop. The counsel for the petitioner for the accused has drawn attention of this court to the discrepancies in the facts stated in the FIR and the statement of the victim recorded under section 183 as well as under section 180 of BNSS. Full stop. Learned counsel further submits that the evidence which is there on record discloses minor offense, discloses only minor offense under section 115 and 315 of BNSS. Where the maximum punishment can extend up to 3 years. Full stop. Per contra, the prosecutor vehemently objects to the grant of bail at this stage and submits that the statement of the informant bracket victim prima facie discloses an offense of attempt to murder releasing the accused at this stage would not be proper as he may pose threat to the victim. Stop. Next paragraph. That upon hearing the rival counsel and on scrutiny of the material on record, at the very outset, this court finds that the genesis of the crime arises out of a relationship stop. The victim in the FIR has categorically stated that the accused is her boyfriend and he tried to muffled her with a shawl. However, on going through the statement of the victim, recorded under section 160 or 180 by the police, this court finds that the victim has disclosed that the accused is her husband. Full stop. The victim in a statement under section 164 is silent about the accused muffling her neck with a shawl and dragged her to the jungle. At the bail stage, the court would not attach any conclusion to the evidence. Nevertheless, the evidence needs to be scrutinized to determine the gravity of the offense, to determine the gravity, to determine the not gravity, to determine the authenticity of the evidence, to determine the authenticity and the gravity of the offense. Stop. This is a case where the investigating officer had collected evidence through e-saksha. Stop. Where is that e-saksha we have access?
It doesn't work in some, but from my mobile phone, it still can open.
The officer collected the evidence through e-saksha. This court has made several endeavors to have access to the e-saksha portal. This court has made several unsuccessful attempts to have access to e-saksha portal. Stop. Stop. Now, this court has to determine the bail application based on the hard copies of the evidence collected through e-saksha placed before this court. Stop. This court is oblivious of the fact that when there is a strain in a relationship, leading to filing FIRs, always there would be an element of exaggeration in the FIR. It is only through investigation the exaggeration can be unearthed. In the case in hand, the investigation has concluded the allegation in the FIR made by the victim and the statement made by the victim before the police and the magistrate is highly inconsistent, giving rise to a strong suspicion if the accused had made an attempt on the life of the informant. Where's the judgment you give me?
Roshan Lal versus
Where's the judgment copy?
State of Haryana and another.
Learned counsel for the petitioner, for the accused, has placed the decision of the Honorable Supreme Court in Roshan Lal versus State of Haryana, criminal appeal number 2207 of 2011, which paragraph?
32.
Where the Honorable Apex Court has elucidated the ingredients of offense under section 307 stroke 109 BNSS. Relevant paragraph paragraph 31 and 32. We'll produce it more. From the evidence collected by the investigating officer. No, the evidence collected by the investigating officer on being put on the anvil of the law discussed above. This court finds that there are no evidence from where an inference can be drawn. There's no evidence, there's no material, there's no material from where a prima facie inference can be drawn that the accused had inflicted injury with intention and knowledge that it would cause death of the informant. Full stop. On contrary, the facts alleged in the facts alleged in the FIR by the informant with regard to attempt to murder is highly inconsistent with the statement of the informant. This court finds that the material on record does not warrant detention of the accused for an attempt to murder. Consequently, the benefit of bail is extended to the accused. Name? Williamson.
Gahar.
The accused is enlarged on bail on execution of a PR bond of rupees 20,000 with one surety of like amount and on the following conditions. Number one, that the accused shall appear before the court and stand for trial. Now, how can I keep a condition if I don't know their husband and wife? Can I keep in a bail order? Can I pass in a bail order that the husband should not meet the wife? They'll go to a civil court and challenge my order. Can a criminal court pass an order saying that in a bail condition that the husband should not meet the wife? That only civil court can do. The accused shall not intimidate, threaten, or influence the witnesses, including the victim. The accused shall not indulge himself in any criminal act the accused shall not indulge himself in the accused shall not indulge himself or indulge himself in any criminal act. This one, the accused shall not intimidate, threaten, or influence the witnesses, including the victim, or cause anybody to intimidate, influence any witnesses, including the victim. The accused shall not leave the jurisdiction of this court without the permission of this court. A bail application stands allowed and disposed of. Yes. The next. Yes. What is this e-saksha? Yes. Please. Yes. Yes. E-saksha, we have access. Yes, please tell us. Yes. What has happened with the e-Saksha in this case?
So actually, it seems that when they registered her mobile number, it was the old one. And now she has given a new one. So now we have updated with the new numbers. So it take at least 24 hours to be reflected in the NCRB.
Then we can see.
Yes, sir. Most
Good.
probably, sir, because this is the first case happening with her. So we don't know yet, sir.
So we'll take it what? Then let it come up on Tuesday.
Yes, sir.
We'll give you time till Tuesday.
Yes, sir.
Coordinate with our court.
Sure, sir.
We want to see all the evidence collected by her. Then we'll hear on the charge.
Yes, sir.
Okay. And then we do that. Then then madam, you coordinate with our staff. Okay, you also coordinate with our staff.
Sure, sir.
What is to be done from our side?
Because now this, we actually don't allow, not allow, but we have to link the number given in section has to be linked with Aadhaar to avoid any unauthorized access. Yes.
So she's not linked to.
She has links, so we don't know yet so which numbers. So now we are trying, sir, both of them.
Do you have something like official number in the police department?
Yes, sir.
Or
We
your
have
personal,
checked the official number now, sir. Just yesterday night we did it. So
or
we don't
your personal number becomes your official number?
I don't understand.
Your personal number becomes your official number, or you are given some dedicated personal numbers
No,
for the
sir.
purpose of e-Saksha?
So your official number is your section number.
That is only for the purpose of e-Saksha.
Yes.
You are
Link
having
with
that.
Aadhaar, sir.
Huh?
Link with Aadhaar.
You have that number, official number?
Yes, sir.
You have one dedicated number given to you for the purpose of collecting evidence through e-Saksha?
So
Or you using from your personal mobile?
I use the same number, sir, for personal and official.
It's not given, sir. It's actually your own number only. We just update the number in the portal, sir.
Her number is updated?
Yes, we just did it this morning again, sir. Because it's
So
still
what is the
number.
flow now?
So
What is to be done now?
So we'll have to wait until it gets reflected in the system.
Sorry?